minute-by-minute updates which are coming in from the courtroom. The judge has entered the courtroom. Our legal correspondents who are inside the courtroom, Akanksha, in fact, tells us that the Muslim side lawyers have already entered the courtroom. Of course, Advocate Vishnu Jain, as we had told you earlier, he's already arrived at the courtroom as well. He is going to be representing the Hindu side. 4 of the Hindu women petitioners are also there in the courtroom. There are 31 people roughly who have been allowed inside. Minute-by-minute updates, the fastest ones coming in. Akanksha is inside the courtroom. Our legal editor Harish Nair getting us the very latest outside as well. So let me go across to Naveen Chomal. Naveen Chomal, if you can explain the entire judicial process today, what is the judge going to be looking into? Because one of the contentions is when the both sides don't have full access to the photographs as well as the videography, can the two sides really argue when it comes to the maintainability of the petition when the survey details are not known to them officially?
See, when the survey was being conducted, at that time representatives of both the sides were present and witnessing what is being recorded for the purpose of the report of the surveyor. So it is not that totally blind to the facts which are being produced before the Honorable Court. And as Honorable Apex Court has given the guidelines how to deal with the matter, so Court has basically logically also guided them that you decide the issue of maintainability of the entire proceeding first in light of the Act of 1991, Places of Worship Act. And of course, as per Order 7, Rule 11, that has to, Rules 7, Order 11, that has to be done on priority. So you see, today the court will be deciding the course, whether to first hear the issue of maintainability of the entire process, and then the court will first assess the report of the surveyor and entire proofs. So if there are certain material which may be hurting the sentiment of certain party and which may not be necessary for putting in the public domain, so court may truncate that particular part of the report and then make the report public for the access of both the parties. And on that basis, the entire matter would be going on further. That is the course of action. That's going to be the judicial course of action today. A quick update from Harish Nair, if you can quickly tell us. I believe there is heavy police deployment also which has been thrown outside the courtroom.
Yes, that's right, Meghna. Heavy police deployment outside the courtroom and also the court complex. And just like yesterday, only 32 people have been allowed inside. They are the lawyers who hold the wakalatnama for both sides, that is the Hindu side and the Muslim side. The Hindu side represented by several lawyers, and also the 5 women devotees who are the main petitioners in this case. Apart from that, no media person has been allowed. Just like yesterday, to avoid commotion and chaos, all other lawyers unrelated to the case, curious onlookers and media have been kept out of the courtroom. So we are largely relying on what the lawyers coming out of the courtroom will have to tell. There are also reporters.
Well, in fact, even as we speak, we can see the visuals of Vishnu Jain. He is, of course, representing the Hindu side petitioners. He's entering the courtroom. Along with him, you can just about spot the 4 women petitioners as well. There you can see them in the middle of the screens. The 4 women petitioners and Vishnu Jain, all of them going in. As Harish was saying, look at the number of people. Look at the interest that this case has whipped up in the district court as well, which is why only 32 people have been allowed inside the courtroom, the petitioners and their legal representatives. Now, Advocate Ehtesham Hashmi, if I can come to you, the Hindu prayer is very simple. That let this case, and as and when the courts decide, let this case continue in the judicial process, and due diligence is going to be done by all the courts. It's there in the Supreme Court. There are some pleas in the High Court, of course, in the District Court as well. But in the interim, allow us to go there and pray. They are allowed once a year, allow us to carry out daily prayers. Is that maintainable, at least that plea?
Actually, there are a set of rules and procedure which needs to be followed by each and everyone, by the judges, by the lawyers, by the plaintiffs in the present case. As far as plaintiffs are concerned and defendants are concerned, all are bound by Constitution of India and Civil Procedure Code. And there is no such law which can permit directly to the plaintiffs who are claiming something, who are claiming that Gyanvapi Mosque is a mandir and they want to worship there. it cannot be done because there are no such guidelines and ruling regarding the same. And as far as the decision of his case is concerned, the matter is pending before a district judge. Now, senior most district judge will decide the case. And first of all, it should decide that whether Place of Worship Act applicable on that proceeding or not. They have to decide it first because maintainability needs to be argued and decided at very first instance. Then only next step can follow.
Okay, that's what the Muslim side has also contended, that it is a Place of Worship Act which is going to be at the crux of this. Of course, the court is going to decide. But meanwhile, even as we speak, those are the latest visuals which are coming in. You can see Vishnu Jain, but now you can also see very clearly the 4 Hindu women petitioners. They are the 4 petitioners who had moved the court saying that they should be allowed to carry out daily prayers at this, and that it is their contention that their doors to Asta have been shut down by the way that the masjid has blocked the entry of Hindu devotees there. They are allowed once a year, which is their basic plea that they have been saying, at least allow us to pray in the interim. Now, Acharya Vikramaditya is also joining us, a spiritual leader. Vikramaditya ji, this is very interesting because even as we wait for the court to decide which plea is going to be coming up first, the Hindu side says at least our right to practice our religion, which is a fundamental right, that cannot be denied to us.
Certainly, that is a basic thing. We are demanding this thing that we are praying from last 350 years over there, and even before that, even after the demolition of the structure, after when the Aurangzeb did all the disaster, and even till 1994, the prayers were going on a regular basis. But at the time, the SP government comes over there and they basically put that hindrance that the Hindus can pray just for one day only in whole year. Before that, the prayers were going on. We are simply praying this thing, let the prayer be continued. We are demanding this thing from last 25 years. And even after that, the survey was done, which was hindered by the Muslim people in 1995 also. I don't know what kind of argument Mr. Hashmi is giving on the channel that the Hindus are. We are not demanding beyond that. In this petition, we are simply demanding that let the prayer continue. We are not asking for the whole temple. That survey which was done, that is revealing the totally
answer what Vikramaditya is saying. We're not asking for too much. We're not even asking for a full-fledged mandir. We're not trying to stop the prayers, the namaz to stop either. We are just saying give us access to the idols. Sayyid Jawad.
मैं विक्रमादित्य जी की बात सुन रहा था. देखिए, कभी मुस्लिम पक्ष ने जो है इस चीज के लिए मनाती नहीं करी. आपकी मर्जी अगर सरकार से है तो आप सरकार से जवाबदेही करिए. सुन लीजिए, कभी मुसलमानों ने कोई आपत्ति नहीं जताई किसी चीज को लेकर के. सरकारों ने रोक लगाई है तो आपकी नाराजगी अगर सरकार से तो आप सरकार से
तो आप बोल रहे हैं कि मस्जिद कमेटी को कोई प्रॉब्लम नहीं होगी अगर वहां पर अलाउ किया जाए हिंदूज को वहां पर जाके प्रे करने के लिए डेली प्रेयर्स. तो आप बोल रहे हैं उसमें कोई प्रॉब्लम नहीं है.
मैम देखिए, 1991 का प्लेसेस ऑफ वर्शिप जो है वो हम नहीं लेकर के आए, वो सरकार लेकर के आ रही है. और उसके अंदर जो है ये बोला गया है कि जो 1947 से पहले की परिस्थिति वो एज इट इज रहेगी. किसी मंदिर, मस्जिद, गुरुद्वारा किसी के स्टेटस को चेंज नहीं करा जा सकता. अगर 1991 का प्लेसेस ऑफ वर्शिप है यहाँ पर तो आप इस चीज को जो है संसद के अंदर पलट दीजिए. किसने आपको मना कर दिया?
Naveen Chopal, that's a very important point. Naveen Chopal. And that is something that even the likes of Subramaniam Swamy accept, that Places of Worship Act is going to be one of the biggest hindrances to the Hindu side. Do you think that is going to be the deciding factor for that? Because you have the government who has an option of even pushing in a bill in the parliament if they decide to scrap it.
Definitely, my answer is positive. The government, I think, should scrap this particular mischievous act. It was brought in with a mischievous intention, and that is basically contrary to our secular fabric also, and right of any individual, fundamental rights of place of worship. Plus, Section 3 of subclause 3 of clause 4 of that particular act is very clear. Let me read it out to you. Nothing contained in subsection 1 and subsection 2 shall apply to any place of worship referred to in the said two subsections, which is an ancient and historical monument or an archaeological site, or remains stored by the Ancient Monuments and Archaeological Sites and Remains Act 1958. So you see now, because of this particular exception in the same act, there is no scope for the Muslim side to say that this act will prohibit the Hindu side from claiming the temple also. So definitely the survey has taken place.
Would you agree to that?
The proofs come.
Mr. Hashmi, would you like to come in lawyer to lawyer?
Yes, please. Hello.
Yes, go ahead, Mr. Hashmi.
Let him reply to clause 3 of section 4. That's all. What does he have to say about that?
Go ahead, Mr. Hashmi. Mr. Naveen Tomal says that this act is not applicable. It is a mischievous act which was pushed in 1991 by the then Rao government.
That has not been decided by Supreme Court yet. Act is under challenge before Honorable Supreme Court of India.
Mr. What do you have to say about clause 3 to section 4?
He asked you a pointed question.
Place before Honorable Supreme Court of India, Honorable Supreme Court judges have not said that this act, Place of Worship Act, is not applicable on this issue. And that's why learned district judge will first decide the maintainability. And I can challenge.
Mr. Hashmi, you ducking the question.
You are ducking the question. I'm taking the bull by the horn. I'm accepting that particular, let the act be there, and let us go by that act also.
They've accepted that act is there, Mr. Hashmi. He asked you a pointed question.
Okay.
Yes.
Let us debate
What was
let us debate on what was the intention of legislature behind.
Well, clearly you don't want to debate on the Places of Worship Act. We just going to come back to you. This is interesting. We'll just come back to you. But a quick word from Harish as well. Harish, what are the latest updates which are coming in from the courtroom as we are still awaiting to hear from the court? I believe the order will be coming out around 2:30. Any updates?
Yes, in fact, initially it was told that the order will be dictated around 2 o'clock. The operative portion will be read out 2 o'clock. But later it was changed to 2:30 because the judge wanted to clear all those who are not associated with the case out of the courtroom, the other lawyers related to other cases, and only 32 lawyers connected with the case and the court commissioners have been allowed inside the courtroom. And just like yesterday, even the media has been barred from the courtroom, so it's expected that within in any moment the order will be out. The district judge will be pronouncing as to which petition the court will be hearing first. Is it the maintainability suit or the advocate commissioner's report as per the demand of the Hindus? And the court will also lay down certain guidelines as to how the hearing should go about, and fix a timeline, and also decide as to how much time can be given to each lawyer of both sides, and therefore the time schedule will also be fixed. And there are also other petitions, like the Hindu sides have sought permission to worship the shivling which was discovered at the Vazukhana, and as you rightly said, the crux of the entire matter is the Places of Worship Act. The Hindu side have said that they cannot argue the maintainability suit, even if as per the directions of the Supreme Court, the district judge takes it up on a priority basis. The Hindu side have said that they need the support of the advocate commissioner's report. Not only the report, but also 1,500 photos which the advocate commissioner submitted as annexures to this report, and also 10-hour-long video clipping.
But even as we speak to you, Harish, the hearing has begun. That's the big breaking news which is coming in. The latest information which is coming in is that finally the Gyanvapi hearing has begun in the district courtroom, and Harish has been telling us what exactly are the pleas that are going to be heard. Harish, if you can quickly give us an update that what is the most contentious plea which has been put up, that regarding the Places of Worship Act, which you were explaining right now, and how that could be the crux at a time when the Hindu side is saying that it's more important that the advocate commissioner's survey report, which has over 1,500 photographs as well as close to 10 hours of videography evidence, should be looked into and discussed first.
Yes, that's right. As we all know, this Places of Worship Act is at the center of this entire dispute. While the masjid side says that the petition filed by the 5 women devotees are barred, is in violation of the Places of Worship Act, and should not be entertained. Remember, the Places of Worship Act provides for a status quo on the religious worship, status of religious worship as on 15th August 1947, and Masjid side also says that even the Ayodhya judgment had upheld the validity of the Places of Worship Act, calling it it is very essential to maintain the secular fabric of the country. But at the same time, the Hindu side argue that the Kashi Vishwanath, the Gyanvapi complex is exempt under Places of Worship Act. It comes under the ancient monuments and archaeological survey and 1950 Act 1958, and also says that this petition, this particular prayer is only for right to worship and not for ownership or change the character of the complex. So even the Hindu devotees were praying even before 15th August 1947, and therefore these places of worship will not be applicable in this regard. They also argue that though the Supreme Court judgment in Ayodhya had commented about the Places of Worship Act, they were mere observations and does not have the force of a law and is not binding. And separately, the Places of Worship Act is under challenge, and Supreme Court has already issued notice on it. So as you rightly said, the fight is all about the Places of Worship Act, and any time now the order will be out. Let me tell you that the judge has already assembled and is already the court. Yes, the Akanksha is
Harish, the updates that we are
from
getting, even as you catch up with what is happening inside the court right now, we are being told by our colleagues who are inside in the know of the proceedings as well, that the Muslim side is presenting its case. Now, explain that to us. We were told that the judgment has been reserved, and today the court has only come out and pronounced as to what is going to be the frequency of hearings, the timeline, the dates, etc. What really could the court be hearing today?
Yes, Priya. Once again, it looks like the Muslim side is once again harping on the fact that even the Supreme Court had said that the maintainability suit, that is, the court should first decide on the maintainability of the petition filed by the 5 women devotees, and only after that it should go into the other issues like the court appointment of court commissioner, and also the survey and the other prayers being made by the Hindu side, like permission to worship the shivling which was recovered from the Vazu Khana, and also some petitions filed by the Muslim side also seeking de-sealing of the Vazu Khana particular areas around the pond, and also the Hindu side petition seeking demolition of a wall behind the Vazu Khana, and also clearing of the debris to inspect whether more idols and motifs are present below the debris. So Muslim side may be continuing to argue that the district judge should not look into other matters on a priority, but only the maintainability suit, because yesterday, Priya, remember, only 45 minutes hearing was possible, and today maybe the district judge has decided to hold a hearing for some more time before he pronounces the order. Back to you.
Right, so for now it looks like there is a resumption of a fresh round of arguments, starting with the Muslim side presenting their side. This is a continuation from what happened yesterday, because remember, yesterday was day 1 of this hearing and it was only 45 minutes that the proceedings happened, after which the news that came out was that a judgment has been reserved, which automatically translates into that conclusion has been reached by the court. It has only been pronounced today, but given the contentious nature of this case, what it now seems is that the court might be hearing once again the arguments that have to be presented by both sides before coming out with its final verdict in the case. I'm also now joined by several guests. While there is a lull in the proceedings and developments coming in from inside the court, Harish, we'll let you catch up on that information. I have Acharya Vikramaditya, spiritual guru, in the studio. Naveen Chomal, lawyer, joins us. Advocate Ehtasham Hashmi, political analyst. Syed Javed, Muslim activist. Naveen Chomal, as a lawyer, if I could come to you first, how important it is for the court to decide on the sequence in which the pleas will be heard. Now we know that the Supreme Court had indicated in its order that, and the Muslim side is also citing this fact, that it should start with the maintainability of the survey plea hearing. How does that bear on this case?
Exactly. I agree with what you are trying to focus and inform our esteemed viewers, that we cannot put the cart before the horse. So ultimately what has to be done is, we have to first decide the maintainability. If the petition is not maintainable, then there is no point in deciding and hearing the entire petition and then discuss over the maintainability. So naturally and logically, the Order 7, Rule 11 has to be given the preference, and we are trying to take the bull by the horn. The Hindu side has got all the facts, all the law points in their favor, and even the survey report will also substantiate their claim. So let the maintainability issue be decided first. And once that issue is decided, particularly in view of the section 3, section 4 clause 3 of that particular act, that which basically exempts the ancient monuments and places of worship, and which are covered by the Ancient Monuments and Archaeological Sites and Remains Act. So once the maintainability is clear, then there is no dispute. The matter can go on. The court can hear the matter based on the survey report, whatever has come, whatever the evidence has come. So there is.
Why does then Hindu side not wait for the court to decide? Why are you seeking prayers right now to be allowed? Isn't what Mr. Chomal is suggesting the natural course of action? Sir, I think you've muted yourself. If you could just unmute your...
No, I think I'm not unmuted my...
Yes, now we can hear you.
So both are juxtaposition, I'm saying, because till 1991, the Hindus were worshipping daily in the Sringar Gauri temple. So what they are basically asking is basically restoration of that particular practice, and they should be allowed to worship, because we have the fundamental right to practice our religion. That is the contention of the petitioner. So both the issues are juxtaposition. So that's what we are saying, that though the maintainability can be looked at, but this particular aspect is a different aspect. So this cannot be hindered by the particular maintainability issue.
If I could also bring in Acharya Vikramaditya here. Sir, what are you expecting from the court today? What will be for you an acceptable and ideal decision by Ajay Krishna Vishwesh, I'm sorry.
My point is basically there is some correction. Just before the speaker is saying this thing that there is date. We were praying till 1994, not 1991. In 1994, SP and BSP government, coalition government was there, and they passed an order just to revert the things that after 1994 March, you can pray just once in a year. Before that, the prayers were going on a regular basis till 1994 March. Not 91. Until 1994 March, the prayers were going on a regular basis. And this is the basic thing. And this was heard by the court already. And because of, after hearing this thing, the court made the survey, the survey demand was raised, and
right,
that was accepted by the court. We don't have any problem. We know that our case has already been accepted. That
right,
we don't have any problem. The problem is after the survey, the facts which came in a new vision, they are on the top. Even if they just ignore this thing, this shivling, how can you ignore these photographs?
Right.
The photographs which I am showing you.